Yeah, after the debate that took place here in the Dáil on the mother and baby homes, because like many other TDs, we were overwhelmed with the response of people out there and the anger and the anxiety, concern and so on, particularly of those who had been in those institutions, who'd suffered abuse in those institutions. And I held an online public meeting which had hundreds of people, many of them who'd suffered really horrific abuse and so on after that. And they were really very, very angry, Taoiseach. And their anger can only have been magnified by what has emerged since, that the Minister misled the House about the advice from the Attorney-General. There was no advice. And the suggestion that GDPR did not apply under the condition, particularly the condition that it might jeopardise future commissions or the work of the Commission, that was not a basis under GDPR. So why did the Minister claim that he got this advice from the AG? Why did he claim something that simply wasn't true when GDPR did not do as he suggested it did, or that it applied in a way he suggested wrongly? And more generally, what was expressed by the survivors and those who had a stake in this was how angry they were that they were just not consulted, weren't part of the process and weren't at the centre of the government's considerations in terms of how to deal with this matter. And even on things like the archive that's being proposed. I mean, what was said by the survivors is, this is the place where the narrative will be set about our lives and our histories. We want to determine that narrative, not somebody else, not so-called experts. We want to determine the narrative about our lives and our histories. We want to have a real stake and real involvement in how that archive is operated, and that there should, even now, because even after the admission following the Data Protection Commissioner's intervention in the debate, I think you said, or certainly the Minister said, oh, the right is not absolute. The right to people's information history is not absolute. Right? That's very worrying. Misleading the House about GDPR, and then saying your right to your identity and your history is not absolute. And all of that sort of adds to the suspicion of a group of people who've been robbed of histories, identities, abused, and so on. So there needs to be an admission that what was said was wrong, and there needs to be a putting at the centre of this entire process the needs, wishes and the direct involvement of the survivors and the people who have a direct stake, where their identity and history is at stake in how we deal with this matter.
First point I would make is that in the last decade or so, the state has opened up in an unprecedented way, and did on many issues. I myself would have initiated the inquiry into the industrial schools as Minister for Education. Many people didn't expect that would happen. I was the first to do it, despite many of the survivors having gone to successive governments before that without any satisfaction. And likewise, we introduced and started inquiries into the church in relation to sexual abuse. I initiated the inquiry into Ferns, for example, and the then Minister McDowell in relation to Dublin, and Barry Andrews in relation to Cloyne, without fear or favour. And that happened. And a previous government initiated this inquiry into the mother and baby homes, which was designed an inquiry to reveal and to open up the story. So I think it's very disingenuous and wrong of the opposition and Deputy MacDonald there to suggest that someone was trying to undermine people's rights or trying to sort of seal off archives. That is the opposite of the intention of setting up a commission of inquiry in the first instance. And the same with the Magdalen and Laundries, which the then Taoiseach Enda Kenny would have initiated. Why? To open up. Now, in terms of GDPR applies. It's a European law. It applies to all records. And people can apply under GDPR for access to their data in all records. That gets adjudicated upon, Deputy Barrett. You know that too. And in terms of 2004, it relates to certain people giving evidence so that we could find out what was going on in these institutions and who wanted to avail of confidentiality clauses, that they would be protected as well. That was the whole basis of the 2004. A very good article by Patsy McGarry in the Irish Times, which lays out all of that, and which he was making the point that the provisions of that Act enable us to find out an awful lot more and enable us to have these inquiries in a more expeditious and effective way. But also I think it's important that the deputies opposite would acknowledge their failings as well. Because I think you misrepresented the Act that was passed, the Records Act, deliberately so. Could one imagine the debate we would have had in this House this week if it was discovered that the Minister, having been told by the Commission of Inquiry that if you don't act, if you don't bring in legislation, these records will be destroyed, rendered useless, rendered redundant? Could one imagine the furore, the uproar that there would be in the House if the Minister hadn't acted to bring in legislation? And those were the reasons, the bona fide reasons why the Minister brought in that legislation. And you need to show humility as well, because some of the assertions made in that debate were wrong. And the Minister's bona fides were wrongly undermined. He has no interest in closing off any archive, none. Yet he was presented as that. And that was wrong. And that didn't do public debate any good either. And it didn't help ease the anxieties and the genuine concerns of the survivors, which is what should be all of our primary concerns. And the Commission of Investigation, they have compiled, as you know, a database of all the mothers and children who were resident in the main mother and baby homes. And they said to the Minister that it's clear that this database would be of considerable assistance to those involved in providing information and tracing services under existing legislation. They said the database would have to be effectively destroyed. As the information compiled in the database is all sensitive personal information, the Commission would be obliged under existing legislation, that's prior to the Records Bill that the Minister brought in, the Commission would be obliged to redact the names and other identifying information about the residents of these homes before submitting it to the Minister. Now, is that what we wanted? Of course it's not what we wanted. And the Commission stated that this would have the effect of rendering the database useless. Is that what we wanted? Of course it's not what we wanted. And that's why the legislation was introduced in a hurry, I accept, to make sure that by the time the Commission's report was sent to the Minister, we would have protected the records for the survivors so that they could access them under GPDR. Yet that got horribly misrepresented. Now, the Minister himself accepted he should have consulted with the groups. He accepted some fault in relation to communication. But in my humble opinion, it still shouldn't have been misrepresented and distorted to the degree that it was that weekend. And I'm just putting that on the record of the House in a fair manner, and I'd like some acknowledgement of that too.
Thank you, Taoiseach.
And I think I want to work with the House.
We need to move to questions.
Just finally say, I want to work with the members of the House on this. I'm committed in terms of a centre which will tell the story and will give people access. And the government is on the side of giving as much access as we possibly can and applying GDPR to the optimal to vindicate the rights of access to information of survivors of these institutions, of all three. And I would ask people to accept our bona fides in that regard. We have no other agenda, I can assure you.
Question